Well, hello everyone. How are we today? Good afternoon, good morning, good evening, wherever it is that you're coming in from. Well, believe it or not, we're going to be able to see this Zoom hearing today. I don't know what to expect. This is in regards to Brooks's appeal with the Waukesha trial. He doesn't, well, he wants to fire his current appellate attorney and represent himself, and he has to now go before Judge Darrell for her to have that approved to happen. I I don't, poor Michael Covey, his current appellate attorney, I think is going to end up being stuck with him. I just don't see it. I just don't see it happening, you guys. I mean, it part of the whole, if he even has a chance at appeal, it's because he represented it himself. I mean, it's just it's insane. And I just don't see how she's going to give it any credibility. Uh Really quick though, shout out, someone had sent me an email, and I do appreciate you reminding me of this. Zach Witchow, our one of our favorite over at the DA's office in Waukesha, did win his judge. Is it a judgeship? What do you call it? He's on the bench now. He won. I don't know when it goes into effect, but so he won that. And then you've got Leslie Basie, who's now the DA. Sue Opper is coming back, I think, just on this one case that we've been seeing a little bit on, that she was involved with. And then she'll be gone. She'll be retired for good. And then we also had Detective Carpenter as well on another case that we were looking at. A lot going on with all of our people in Waukesha. And you know how we love Waukesha here on this channel. Absolutely adore them. Strong, resilient group. Uh, The classiest town I have ever seen, because I can tell you that not many towns would have handled Darrell Brooks and that situation, that whole court thing, the way that they did. I give them so much credit for all of that. Let me do a quick screen share of what we're going to be watching here today. Yes, Law and Crime is the one that is going to have this up for us. Remove me, Den. Remove me, Den. I don't know. Do you think he's going to say that? Remove him, Den. Darrell, Judge. I want to see all. Oh my gosh, I haven't even looked at the comments yet. Okay, so go ahead. Let's hear it. I got to look in the comments and see all of your little different things. I want to hear our old school. Oh, I got a grounds. Can I get a grounds? I got a grounds. Also, I would like to say that the Brooksaholics anonymous meeting is officially under order. Let's see. Free my home. What? Free my homie? Oh, okay. Yeah, that's funny. Appeal hearing. I know this doesn't even happen usually, you guys. I mean, this is just so. Am I muted? This is so insane that this is even. uh, I don't even have words for it. Has this ever happened before? But of course, there's a lot of firsts with this trial. I just heard the other day, not too long ago, and I can't remember where I saw it. That might have been an article. There's actually laws in place now because of this moron in his trial. There were some regulations or laws or something that were put into place that happened because of the way his trial went. And I don't know if it's necessarily if it was the way it was handled or what, but it was like they were basically saying, this could happen again. And if it does, we need to be more prepared for it type thing. I have to look it up because I don't remember. I don't remember what it was I saw. Laura said, I told you, if you guys, if it could be found, Kerry would cover it. Yeah, I was getting a little nervous there. I'm not gonna lie. Because I kept looking for this notification that it was going to come on, and I even got in touch with Waukesha to see if the court would allow me the private Zoom link or something that we could put on the. I didn't get anything. I could get anything. So yeah. Oh my gosh, John Bubba is back in the house. John Bubba, you only come to see us when Brooks is on, and frankly, I'm just I got a complex about that. I must say. Hi, Mark, aka Mr. Timeout. There's a country song about that, I think, Mark. I'm not positive. Oh my gosh, Laura. She's been a member for 11 months. Laura, I swear I think you have 2 memberships. I'm not even kidding. Uh, Thank you for all your support that you give me throughout the year. You and Bama both are amazing. I appreciate you guys so much. Let's see who we got in the house. I'm looking back. Is there any names that I haven't seen in a while and you guys just come sweeping in whenever to come say hello? You know what? My channel does run on other things other than just, Darrell Brooks. I have other things that we talk about. Like we got a lot of stuff. Oh, by the way, we're going to be streaming Lori Vallow Daybell's trial next week. So that should be interesting. Yes, I believe he's going to ask a lot of questions. I'm a goat. I don't know if that's a compliment or not. I've never been called a goat. Coming from Mark, it's probably a compliment. Subject matter jurisdiction. Oh, so I heard that this morning that Taylor Schabusiness went on a rampage again after her attorney. And so I thought, I don't know how long this is going to be, but regardless, I thought we could watch that afterwards because I missed it. I haven't been home. So we can watch all that together. I mean, it's like a double feature picture show, the Rocky Horror Picture Show here with those two. Mark said, you never should have pissed off the Freeman, the Waukesha Freeman. Yeah, right. Okay. Oh, when he put that article out and mentioned me, I should have said grounds. Shame on you. But you know what? I've heard that. I hear that a lot. People say that reporters will do that. They'll take your words and twist them or whatever. So I guess I had that happened to me for the first time with that. Here we are again. Hi, Death Nail. Good to see you. You got something you want to bounce my way, John Bubba? Do you have my email address? Email me. It's in it. My email address is in all my description of all my videos, my videos. You can email me. And by the way, if anybody here is watching my channel is unaware, something I just saw today that made me kind of go, I have got all of my book stuff. I don't know what to say all of it. I have a majority of my book stuff under Waukesha Parade Tragedy. And I probably should just change that and do a separate, like just a Darrell Brooks thing, because I think people go in looking for him. And it might be hard for some of you guys to find it. And I didn't think about that till today. You guys, when I look at my analytics, you would not believe more people watch. It's really kind of sad. More people watch Darrell Brooks, my old stuff, than they do my new stuff. So, yeah. Hi from Finland, the Guinea. I wanted to play Sarah's song so badly when I put the 90611 up. It's so bad. But I thought, no, I guess it won't make sense. Maybe we could play it on the outro, though. I do miss that song. Hi, Charlene. It's really good to see everybody. I'm not going to be able to catch all of you to address each and every one of you. So thank you for being here. Why didn't I try Karen Reed? Are you talking to me, bud? You know what? That's so weird. I never got into that trial. Never got into that trial. Like, I don't know what I was working on. I think I was working on Brooks when that whole thing started. And so by the time it came to my attention or I was able to have time to do something else, it was Kieran Reed had already taken off. So it was kind of it was hard it's hard to come into something when you haven't been covering it very long. That's kind of what we were doing here with Lori Vallow Daybell's trial. I know enough to be dangerous on that one because I have done some research, but I've been playing some old stuff from then so that people can catch up. I just put out today Alex Cox's interrogation from after he shot Charles Vallow. And then we had before that, was it yesterday? We did the body cam footage of Charles before. You guys, there's no way that Charles Vallow attacked Alex Cox with a bat. I just can't see it. You see how that man carries himself, the way he acts? I just can't see it. I can't see him doing that. I want to know who hit Alex with the bat, if that was even what injured the back of his neck, head, whatever, because it wasn't that big of an injury. Yeah. They're like Mark says that Brooks's videos are like Gone with the Wind, Wizard of Oz. Oh my gosh, isn't that sad? They're like the classics. Maybe I should put them in black and white. 90611, playing those throw out jams from the sky to the ground. Stay locked up to the 90611, where we will help you find your subject matter jurisdiction. Am I muted? All right. What's going on, law and crime? Let's get to this. Let me go back over here and I'm going to refresh just to make sure. Because sometimes you have to do that. Okay, it still hasn't come on yet, but it'll be there. It'll be there. Did you guys get your popcorn? Illinois versus Allen. Thank you, Drewski. Get your popcorn ready. I wonder how long this is going to be. This is going to last. Why is something always so funny over at that table? Your Honor, why are they always talking about me in that chat? Siles, did I get a chance to listen to the impact statement? Yes, we have a whole video on the victim impact statements. We have a lot, in fact, on the victims. So, um, if you have not seen it, please go look at my Waukesha parade attack video or playlist on my channel. We do a lot on the victims, and we've got like a whole section on the victims getting up and talking to him. And then I did one specific video that just to me was my favorite video I think I've ever done, where it's him clipped and he's saying, well, who's the claimant or who's the plaintiff or whatever. And then I just have all of the people that were victims saying their names behind it. It's really cool. You got to watch it. Like, oh yeah, we've got a plaintiff. Yeah. Have you filed a claim? Yeah, a lot of people have. I'm gonna file a claim too, just because of backlash on him. Oh, you know what, guys? I hope Long Crime doesn't. They wouldn't put this up if they felt like they weren't gonna get into this, though. Surely. Hey, Blanco. Yes, it's right. I know. We got a live with Darrell Brooks. Isn't that crazy? That doesn't happen very often anymore, does it? Drewski doesn't consent. I apologize, Drewski. Hey, Mark. Thank you for gifting 5 memberships. Who are your victims? I mean, oh, There he is. I mean, who are the people that you gifted? Let me take this off the screen. Do I look all right? Do I look all right, Your Honor? Oh, hang on, sorry. Here, I got it. Okay. Oh, they took him off the screen. There's Leslie. Isn't Leslie down there? Wait, is that still Zach?
All right. Everyone, please be seated.
Can't hear it. I'm going to go on mute.
Did you confirm he could see you?
Oh, it's Zach and Leslie. I don't have it on mute. They've got it on mute.
Function of
Oh, I guess I
Zoom
did have it on mute. I apologize. I apologize, Your Honor.
of Zoom that's. Well, good afternoon, everyone. The court will call State of Wisconsin versus Darrell Brooks, 21 CF 1848. May I have the appearances in the courtroom, please?
State by Leslie Beasy and Zach Wichow.
Good afternoon. Attorney Michael Covey appears. Mr. Brooks appears in custody via Zoom.
Mr. Brooks, can you see and hear the court? He's giving me a thumbs up. Are you able to also see your attorney through the Zoom?
What was that?
Are you also able to see your attorney on Zoom? All right, and that's a yes, sir?
Yeah.
Can you answer verbally, please?
Yeah.
Thank you so much. And any objection to appearing remotely today, sir?
No.
And has the state complied with victim rights?
Yes.
As everyone is aware, the court is live streaming through the daycast function of Zoom that CCAP has made available for circuit courts in Wisconsin. And we've been able to verify it is up and running. If at any point in time anyone gets word that it is not, please let me know. We are here today to address a motion to withdraw that was filed by Attorney Covey. I do want to ask you a number of questions. The first question is it your understanding that Mr. Brooks would still like you to pursue this motion?
Yes, Judge.
All right. And Mr. Brooks, could you also confirm that for me, that you are seeking Attorney Covey to be relieved as your attorney of record for your appeal?
Yes.
For purposes of today's hearing, District Attorney Basie, do you agree, or is there any dispute that Mr. Brooks is indigent?
I have no information to say otherwise.
All right. And do you have any dispute that we are concerned with Mr. Brooks's direct appeal rights at this point?
No concerns.
All right. Do you agree with those two issues, Attorney Covey?
Yes, Judge.
All right.
He's absolutely indigent.
He's in custody. He's serving consecutive life sentences. I intend to do that in short order. Is it true, Attorney Covey, that you were appointed for the purposes of investigating and pursuing potentially an appeal for Mr. Brooks on January 6th of 2023.
Yes, Judge, I was appointed for post-conviction and/or appellate relief.
Thank you. And what have you reviewed in your work on this case thus far?
Judge, I have spent probably hundreds of hours. I know this past summer, the vast majority of the summer, my free time was spent reviewing this case, including all of the transcripts, the entire court record, the vast majority of the discovery. I'll make a record of that. There's certainly, when we get provided with lots of audio and video evidence, not all of it is directly relevant to the offense. If, for example, if there's a squad video that's just pointing against the wall, I'm not going to spend hours reviewing that. But the key evidence, the interviews, the court exhibits, I definitely reviewed all of that discovery as well. We have about 5 banker's boxes of materials that I have gone through, including the prior attorney's notes before Mr. Brooks went pro se.
Have you met with Mr. Brooks either in person, by phone, or in any other way?
Judge, I have, and of course I can't talk about the substance of that, but I have met with them in person several times, plus numerous phone conferences as well. I haven't counted, but a large number of contacts.
Have you had written communication with him as well?
Judge, I'll write him letters. Mr. Brooks and I would generally communicate via the telephone, mostly telephone and in person.
Have you sought a number of extensions from the Court of Appeals related to the timing of filing any post-conviction motion or direct appeal?
Judge, I have basically 2 groups of extensions, if I may explain.
You may.
The file is huge, and so it definitely took me longer than normal to review the contents of this case. And so the first few extensions were just to get me through the summertime where I was able to review all those banker's boxes of materials. The second set of extensions were filed so that Mr. Brooks, after him and I had fully consulted each other, would have time to decide how to proceed. I know one of my more recent extensions was to give Mr. Brooks the opportunity to try to hire a different attorney if his family was able to do so. That's part of the public record, of course. So those are the 2 groups of extensions that I filed over the course of the last year and a half.
Do you know how many?
The most recent extension was the sub motion to extend time. That was to give, I'm sorry, my apologies.
The record shows that on
I think there was
February
8.
14th, the 8th motion to extend was filed with the Court of Appeals. Would that seem accurate?
Yeah, I misspoke. It's the 8th motion to give Mr. Brooks time to litigate his case. In the event that I withdraw, he'd have a couple of extra months to review the file and to do his own research.
Again, I understand that you can't discuss confidential communications with Mr. Brooks as his attorney, but generally speaking, have you identified issues to pursue on appeal?
Judge, I can say this. There were several very specific issues that I spent an enormous amount of time researching for appeal. As to whether or not there were viable post-conviction or appellate issues, I'm not able to say without breaking privilege.
Have you sent Mr. Brooks any drafts of pleadings related to any appellate or post-conviction issues?
Judge, since I haven't filed an actual appellate brief, we haven't done the notice of intent to appeal, nor an actual post-conviction motion, there wouldn't be any pleadings for me to send him. So we're at the point, if I may, give a little bit more elaboration. Usually it's a 2-step process for post-conviction relief. The first part's actually the longest. It's assembling the court materials. I know the court reporter worked exceptionally hard to get me those materials, but that took a few months. Going through those materials, identifying issues that could provide post-conviction relief. In some instances, there are no grounds for post-conviction relief, and then there's a different set of options that I would go through with the client. So after going through all of those steps, I did have multiple contacts with Mr. Brook, both in person and over the telephone, for him to decide how he wants to proceed. I'm not able, even if hypothetically I found 5 amazing viable grounds for post-conviction relief or appeal, I wouldn't be able to submit any post-conviction motion or notice of appeal without the consent of Mr. Brooks. If I found no grounds for post-conviction relief, then again, Mr. Brooks would have a set of options that I would have to go over with him. And I can say that we have gone through that process, and he has requested to proceed pro se, which would prohibit me from filing any further pleadings in this matter. I hope that clarifies the issue.
Well, it helps because my responsibilities ultimately, when discussing with Mr. Brooks, is to talk about the options. One option could be a no merit situation. So I generally just want to know if all options have been discussed with him at this point.
Absolutely, Judge. That I can say 100% certain, and multiple times.
Is it your understanding that Mr. Brooks wants to proceed pro se or on his own, or as he sometimes referred to it as in pro person, I think was the phrase he used with some frequency?
Judge, he does want to represent himself moving forward.
Have you discussed with Mr. Brooks your background as an attorney and doing appellate work?
Judge, I don't, it's such it's a innocuous question. There's no issue with me answering it, but I'm afraid that if I were to go into any discussions.
Let me ask it this way.
Yeah.
So I would like Mr. Brooks, and I'd like, actually, let me state it this way. I would like the record to reflect your experience for purposes of my decision here today. So I'll just ask you some general questions. They would not in any way violate any type of attorney-client privilege. First of all, how are you a licensed attorney in the state of Wisconsin?
I hope so. Also, I'm in a lot of trouble today. Yes, ma'am.
How long have you been so licensed?
Approximately 20 years, actually 22 years, I believe.
Do you hold licenses in any other states or have permission to appear in any other courts outside the circuit courts, appellate courts, and Supreme Court in the state of Wisconsin?
Judge, I did take and pass the Illinois State Bar, and I was part of that community for a few years. I let that lapse because I solely practiced in Wisconsin.
What about federal courts?
Judge, I was trained to do some federal courts, and I was actually accepted to be an attorney in the Western District. Then COVID struck, and the caseload for the states became so extreme for lack of public defender appointments that I never ended up practicing in federal courts.
Do you have any area that you focus on in your practice?
Judge, I focus mostly on homicides and sexual assaults, if I may. The state public defender's office, let me backtrack. I'm not a public defender. I'm a full-time criminal defense attorney. For most of the last 20 years, I had my own practice. Recently, I joined Kerry for his law firm, CHIRAFISI. For most of the last 10 years or so, I have been practicing mostly homicides, class A, B, and C felonies.
Give me 1 second. Mr.
Sure.
Brooks, would you please direct the camera up? Thank you so much. I appreciate that.
Judge, the State Public Defender's Office has certifications to take certain levels of felonies. The highest level of certification is Class A felony, and I'm certified to do those in both the appellate and the trial court level. Approximately 20% of my work is with appellate work, I'm in trial more often as with the circuit courts.
In your litigation practice, both in the circuit courts and appellate courts, that's both through appointments and individuals who would privately retain you.
Absolutely. I have the highest level of certifications the public defender's office can give.
Thank you. Have you had any general discussions with Mr. Brooks related to appellate rules and procedures, whether it be formatting, initial briefs, what response briefs are, the requirement for reply briefs, or even the difference between that and a post-conviction motion?
Judge, let me just say this again. I've certainly had lots of conversation with I've spent hours with Mr. Brooks in person and over the telephone. I'm going to speak in very, very general terms. The vast majority of those conversations have to do with the substance of the case itself, the issues that I was researching on this case, and there were some very specific issues which I'm declining to say now for privilege reasons, but that I was researching on this case, going over the case law, meeting with them to discuss lots of different issues. Certainly as part of that, I would have, with every one of my appellate clients, I would have conversations about basic appellate procedures, such as the difference between a post-conviction motion and going straight to the Court of Appeals and why that would occur. That is, as to the details of drafting a brief, rules of citation, the fonts and procedures that you have to do to submit an appellate brief. I, of course, have not had those types of conversations because it was my intent that if there was an appellate issue, I would be drafting that brief. I can say this, and I'm happy to do this to allay the court's concerns. Certainly, it's my intention to send Mr. Brooks a copy of the rules of appellate procedure for Wisconsin. We'll make sure he gets that. Additionally, in my experience of doing this for a long time, though the Court of Appeals will still hold pro se defendants to the letter of the law and the substance of the case, they won't give the pro se defendants any breaks on the substance. If there is an issue with page numbers or citations for a handwritten brief that would be submitted by a prison facility, I've never seen an issue where the Court of Appeals has objected to that. They're a little bit more lenient on those issues for obvious reasons.
Thank you. That was I don't want to say a concern, but a question I had, and that's good to hear. So thank you. Is there anything else you want me to consider in light of the motion that you filed with the court?
Just that I'm not, even if I was allowed to withdraw today, I'm not going to close the file until Mr. Brooks has the entire file. I was speaking with our paralegal staff just yesterday, going through multiple banker's boxes of materials. The facility where he's being kept at right now will not accept those materials. It's just too much for them to take in. However, if we scan them, download them, and put things on hard drives, multi-gigabyte hard drives, we can send those out. So it will be a very lengthy, time-consuming process for us to do so, but I'll make sure Mr. Brooks gets those materials with one caveat. Because of the time and expense to do that, we wouldn't be making multiple copies. So if something were to occur where Mr. Brooks would want another full set of materials, perhaps 8 months from now, it would be challenging for my firm to comply with that request.
So let me make sure I understand this. The prison facility at which Mr. Brooks is currently serving his sentences will not accept the volume of material that you have in paper or even standalone electronic other than on an external hard drive.
If we set them desk and flash drives, I'm very confident the prison would accept that. But they made it clear to our office, and it was their staff speaking with my staff, that they would not accept, if I were to ship 5 bankers boxes of materials, they would not accept that. But if we put those materials on computer electronics, then they would have a place where they could store it safely and easily, where Mr. Brooks could access it in their library.
It is not a secret that Mr. Brooks is no longer being held in Wisconsin. If he were in Wisconsin, would you have had better access to him in terms of going to the facility, even with your own computer, and as his attorney showing him discovery if need be?
So I was able to visit Mr. Brooks at the Dodge Correctional Institution, and additionally at the Wisconsin Secure Program Facility in Boscoville. The prison facilities made it very easy for me to do the visits. I was able to bring my case files. I wouldn't have brought that volume of materials to a meeting anyways, had I desired to go through any piece of audio video evidence. There would have been a mechanism for me to do so in Wisconsin. If hypothetically, if I were to remain his attorney, I am able to have telephone and Zoom conversations with my clients. It would be a little bit more onerous for me to do in-person visits.
If you were able to do Zoom, you obviously can
Yeah.
share screen, even information from your computer.
If that's what we wanted to do.
Do you know what, if any, materials Mr. Brooks was able to take with him from his trial to the facility where he is at?
Mr. Brooks might be able to answer this better than I will, but it's my understanding that somehow along the way, when he was transferred out of state, he no longer has those trial materials. So we would be working to give him a complete set of what we have. And that would also include downloading all the materials from the e-file and putting that on a separate flash drive as well.
But you're willing to do all of that?
Yes, we will get extra funding from the Public Defender's Office to get extra paralegal support to do that.
And they're willing to do that as part of the case closure, should this motion be granted?
I have not put in that request yet, but I am certain they'd be willing to do it. They've done it before on other cases that were also very serious cases. I'm sure I can get the funding.
All right, thank you.
And frankly, if we didn't get the funding, we would do it anyways.
Well, I appreciate that. Thank you. All right, Mr. Brooks, I'd like to ask you some questions. First of all, are you aware that Attorney Covey has filed a motion to withdraw as your appellate counsel?
Yes.
And just as a reminder, even though I tried my best to talk to you at my cameras, when I want to watch you for your response, I look slightly down and to the right, or even to one of the other monitors that I can look at. So I just want you to be aware that when I do that, I'm actually paying attention to you. Any questions about that, sir?
No.
All right. Do you want to have Attorney Covey withdraw and act as your own attorney, sir?
At this time, yes.
The Public Defender's Office sent to this court a letter dated February 26th of 2025. It is front and back. I think the actual filing had some additional information on the third page, but that had more to do with who was copied on the letter versus the crux of the letter. But did you receive a copy of that, sir?
From what was the date?
February 26th of 2025.
I don't believe I received that.
Mr. Brooks, would it be helpful if at this point I switch to a single camera when I'm talking directly with you instead of having the multi-camera view?
I can see you just fine.
Okay, great. So I'm just going to read the letter into the record, sir. It's important. It is from Kelsey Loshaw, the Regional Attorney Manager from the Madison Appellate Office. Does that ring a bell at all?
I think from previous letters it might, yeah.
Well, this one is specific because it was filed after the motion to withdraw was filed, and there's a requirement in Wisconsin Statute 809.30 that the Public Defender's Office advise the court of certain information. Does that help ring a bell, sir?
No.
All right, then bear with me. I will read the letter. It says, "Dear Clerk, in accordance with Wisconsin Statute Rule Section 809.30 sub 4 sub B, I'm writing in response to the motion to withdraw filed by the SPD appointed appellate attorney Michael Covey. The rule requires the SPD to determine whether successor counsel will be appointed and notify the court of the determination. I ask that you pass this on to the judge assigned to the case because the judge is required by Rule 809.30 sub 4 sub C to consider the SPD's response prior to ruling on the motion. The state public defender informs the court and Mr. Brooks if the motion to withdraw Mr. Brooks directed attorney Covey to file is granted, Mr. Brooks will be waiving his right to public defender representation, and no new or successor public defender attorney will be appointed." Sir, have you heard what I just read to you?
Yes,
Are you aware of the risk you take as it relates to to a public defender appointed appellate attorney if this court grants the motion to withdraw?
yes,
Do you have any questions for me about that?
no,
The letter goes on, an indigent person's right to an appointed attorney for appeal does not encompass a right to an attorney of choice or to successive appointments. State v. Evans, 2004, Wisconsin 84, 273, Wisconsin 2nd 192, paragraph 30. If a defendant decides he no longer wants to be represented by an appointed attorney, he has the choice of terminating counsel's representation and proceeding pro se or with retained counsel. Id at paragraph 31. If a defendant elects to discharge his appointed attorney and proceed pro se, the defendant must be provided clear warnings regarding the dangers of self-representation before appellate counsel may withdraw. Id. Sir, did you hear me read the second paragraph of this letter?
yes,
Do you understand it?
yeah,
Do you have any questions for me regarding that?
no,
The letter goes on to provide the legal framework for the court's responsibility in determining whether a defendant validly waives counsel on appeal. And I'm going to read that paragraph. It is a direct quote from a case, State v. Thornton, 2002, Wisconsin Appellate 294, also found at 259, Wisconsin 2nd 157. For your information, State versus Thornton is a Court of Appeals case that dealt with an issue for the first time in Wisconsin in a decision dealing with the court's responsibilities in determining the waiver by a defendant of counsel on appeal. And in that particular case, and this paragraph starts out by giving a little statement about the state's summary of the issues. The state offers the following synthesis of the foregoing decisions. Before a court may conclude that a criminal defendant has knowingly and voluntarily waived his or her right to counsel on direct appeal, it must satisfy itself that the defendant is aware, one, of the Flores rights, parenthesis, to an appeal, to the assistance of counsel for the appeal, and to opt for a no merit report, parenthesis, two, of the dangers and disadvantages of proceeding pro se, and three, of the possibility that if appointed counsel is permitted to withdraw, successor counsel may not be appointed to represent the defendant in the appeal. The court went on, we agree with the state that ensuring a defendant has received and understands the listed information is both necessary and sufficient to support a determination that the defendant tendered waiver of counsel is knowing and voluntary. In that particular case, the issue or the procedural posture was that the appeal was already pending. And so the Court of Appeals had some further things to say about the communication with the defendant being written. That's not applicable here. I'm having a over Zoom face-to-face discussion with you, but this is the framework that will guide the questions that I ask. Do you understand that, sir?
Yeah, I'm familiar with that case law as well.
Thank you. Any questions for me thus far?
Nope.
All right. So I just want to confirm, sir, did you ask Attorney Colby to withdraw?
Yes,
Did he send you a copy of the motion to withdraw?
yes,
Have you reviewed it?
yes,
Do you have any questions about it?
no,
Do you take any issue or claim made by Attorney Covey in dispute?
no,
Did you at any point in time tell Attorney Covey you're fired?
no.
All right.
Judge, if I could just clarify something. The conversations I've had with Mr. Brooks in every instance, they were quite respectful. There was no arguments. So when Mr. Brooks would ask me, when he asked me to withdraw, it was in a polite, respectful way as opposed to a "you're fired, get out."
Great. Thank you. I appreciate that clarification. I still wanted to ask from
Sure.
his perspective. All right. Any dispute with what Attorney Covey just said, Mr. Brooks?
None whatsoever.
All right. Why do you want Attorney Covey to withdraw?
Judge, if I may, Mr. Brooks, this question could cause into some privileged information. You have every right to answer the question. You and I have had lengthy conversations about the substance of particular issues that I have looked at and my conclusions on those issues. I don't think it would be to your advantage to go in that direction. You could definitely answer the judge's questions, but I would just be guarded as to going to the substance of any legal research that I may have done, that I did do. Thank you, Judge.
You're welcome. I appreciate that. I can ask it in a more general way. Mr. Brooks, again, understanding the caveat that your attorney has given you, how would you characterize in general terms the reason you want to proceed pro se? Is it a strategy disagreement, or do you simply just want to represent yourself pro se?
I just want to represent myself.
So let me ask you some real specific questions then about some access to research materials and other things. I believe these questions go to your understanding of the difficulties and disadvantages as a pro se appellate litigant. Most of the time, well, if you file in the Court of Appeals, it is a written process that may or may not include appellate arguments in front of the court. Do you understand that?
Briefly, I understand the outline of what you're saying here.
So you're prepared to follow the rules and procedure of appellate procedure and submit written submissions, whether it be to the trial court or to the appellate court related to your post-conviction and appellate rights?
Yes.
Do you have, or what access do you have to legal research at the institution at which you are currently serving your sentences?
Honestly, not very much. It's very different. Um, so it would take some time, and maybe a few conversations can be had in that area. But I mean, I don't know if that answers your question.
You've answered it. Thank you. Do you understand that could lead to further delays in your appeal or post-conviction motion?
Yeah, I do understand that. I kind of anticipate that with where I'm housed. It's like I said, it's a lot different. Um, Things are done totally different here. So I'm aware that that could pose some issues.
You don't dispute that you're no longer in Wisconsin serving your sentences, correct?
I'm sorry, can you repeat that?
You agree, I earlier said you're no longer in Wisconsin serving your sentences. That's true?
I would rather not say. Or
Judge, I can verify that he is no longer in Wisconsin. The Department of Corrections had requested me personally not to disclose his location. Of course, it's up to the court. I'm sure at some point it's going to get out. But I just had a conversation.
Let me answer that for a second, because
Sure.
we can take a brief segue.
Sure.
I am treating Mr. Brooks no differently than I would treat any individual who's serving a sentence in the state of Wisconsin. I repeatedly asked the Department of Corrections for information where he was at. I am a separate but equal branch of government, and they thwarted my efforts. I was only told he's in South Dakota and given email addresses for individuals that we could have contact. I need to be able, as the court, to send communication to him directly. That would be no different for any other inmate in the state of Wisconsin, whether they have an attorney or not. So today I directed my clerk to send an email to South Dakota and ask them for the information. It was provided and it is on CCAP. I have received no requests to seal an address. I have received no legal authority from anyone and no request. And so I'm treating Mr. Brooks the same that I would treat any individual, and that information is now on CCAP.
Thank you, Judge.
Mr. Brooks, do you believe that despite some of the challenges that you described, or at least stated about access to research, that you'll be able to overcome that if you are representing yourself?
I mean, like I said, it's going to be difficult, but there are conversations that I'm sure can be had to aid me along the way. But I mean, I have to be honest and say that it will be very difficult.
But do you understand that's the risk you willingly take if you want to be your own attorney and proceed pro se?
It's a risk. It's a risk regardless whether I was in Wisconsin or not. It's just going to be, the question was based on where I'm currently housed, which is more difficult than if I was still housed in Wisconsin.
I understand what you're saying. I'm aware, but do you acknowledge, sir, that that is a risk that you willingly take by asking if I approve the motion to withdraw and you appear as your own, you proceed as your own attorney? You understand that?
Yes.
All right. And again, I'm not trying to be nitpicky here. I'm trying to make a record, and I believe it goes to the dangers and disadvantages of being a pro se appellate litigant who is serving multiple consecutive life sentences, meaning you're in custody, further complicated by the fact that you're serving those out of state, and you don't apparently have the same access to resources as you would in Wisconsin. Do you disagree with anything that I just said?
No.
I want you to be aware, sir, that you have the right to counsel on direct appeal. Do you understand that?
Yes.
Do you have any questions for me about that?
No.
As you know, Attorney Covey was appointed by the State Public Defender's Office, meaning at the government's expense, to investigate and review your appellate options. And that the Public Defender's Office, through that letter that I read to you, has advised they will not appoint successor counsel under really any circumstances. Do you understand that? You want me to restate that?
No, I said yes.
Oh, I'm sorry, I didn't hear you. You covered your mouth, so I couldn't even see your mouth moving. All right, you understand that, sir?
Yes.
Do you have any questions about that for me, sir?
No.
The right to counsel in this circumstance, and I'm referring to not only 809.30, but the Wisconsin Constitution, Article 1, Section 21, includes the right to a direct appeal, the right to assistance of counsel for the appeal, and includes such thing as the right to opt for a no merit report and abandon an appeal, essentially. Do you understand all of those things?
Yes. Yes.
Thank you. The right to counsel, however, does not include the right to appointed counsel of your choosing. Do you understand that?
Yes.
It also does not include the right to insist that your appellate attorney pursue issues which he in his professional judgment choose not to advance. Do you understand that?
Yes.
In other words, if the only dispute, let's say, is over strategy and you change your mind later on, that's in that circumstance, the SPD will likely not reappoint. I mean, they've said that in their letter. You can change your mind, you can have remorse, regret, you could try to find your own retained attorney, and if that doesn't work out, that once this court grants the motion to withdraw, they will not appoint successor counsel. Do you understand that?
Yes. And to be clear, there was no disputes between me and Attorney Covey. So there was no strategy disputes. There was nothing of the sort.
Sir, I know from presiding over a previous hearing related to the waiver of attorney that we spent a fair amount of time going through your background. And I just want to confirm a few things with you. You can read, write, and understand the English language.
Yes.
You completed high school through the 11th grade and obtained an HSED. Is that also true?
GED.
A GED. All right, thank you. Are you currently taking any medications that would interfere with your ability to understand what is going on?
Not currently, no.
All right, do you have any medical issues that would interfere with your ability to understand what's going on today?
No.
Are you under the influence of any alcohol or drugs today?
No.
It is also true that throughout the trial in this case, you represented yourself.
Yes, that's true.
Is there anything about this court hearing thus far that you have not understood?
No.
Are you asking this court to allow Attorney Covey to withdraw as your attorney of record?
Yes.
If you change your mind, I want to confirm once again that you are aware the Public Defender's Office will not appoint successor counsel.
Yes.
Are you aware that if you can't hire or retain an attorney on your own, the Public Defender's Office will not appoint successor counsel?
Yes.
Do you understand, sir, that you will be responsible for all aspects of your post-conviction litigation and appeal, including compliance with all court rules and procedures?
Yes.
Anyone make any threats or force you in any way to waive your right to an attorney in this case?
No.
Anyone make any promises to you in exchange for your waiver of right to an attorney?
No.
Do you believe you're making the decision to waive your right to an attorney freely, voluntarily, and intelligently?
Yes.
Do you need any more time to talk to Attorney Covey regarding your request that he withdraw?
No.
Do you further understand you may need to file motions in the Court of Appeals seeking an extension of time? Given the most recent extension goes to June 3 of 2025.
Yes, I'm aware. I didn't know it was that soon, but yes, I do understand that.
Judge, may I jump in for 1 second?
You may.
Thank you. And just for the record, we have sent Mr. Brooks copies of all of our extension motions and the Court of Appeals decisions. What I will do for Mr. Brooks is I'll send him again that my most recent extension motion that he can use as a template. And I'll include a closing letter with the instructions as to how to file that and to use a pre-appeal case number, some of the basic procedural issues that might help him understand the difference between a post-conviction motion and going straight to the Court of Appeals. Is, from my experience, the Court of Appeals is pretty lenient in giving at least several extension motions to pro se defendants. At some point, they'll put some harsher deadlines on. It's a gray area, but I am very, very confident that he'll have more time than June 3rd if he makes a proper request to have more time. It might take a couple of weeks for us just to get at those files to him. We've been working on it.
Mr. Brooks, do you understand that if the court permits Attorney Covey to withdraw today, you would be responsible to file the next extension request?
Yes.
And you are prepared to do that?
Well, once I receive the templates that Attorney Covey is going to send me, yes, I'll be ready to do that.
You understand he's not required to do that. He's just offering to do that, and it would not.
I know.
All right. You understand that's still something you are responsible for, whether he sends you that template or not?
Yes.
Is there anything else you want me to know or consider today, Mr. Brooks, as I consider the motion to withdraw?
Not really. I think everything was pretty much covered. Just understanding should be there that, you know, again, this facility is a lot different. So there are different types of hurdles that I've already seen that I would have to jump over to be able to get things done. So I just want that to be stated for the record, that it's just a lot different, and there's a lot of different procedure wise things here. So I'm still navigating that, as I haven't been here that long. So I'm still learning as I go. So that's it.
And you're willing to take on your own case with that difficulty and those challenges related to the institution?
At this time, yes.
Attorney Colby, anything you think I've overlooked here today as it relates to this motion?
Judge, I'm very satisfied with the colloquy. I think just to make a record, I have just one other issue. If I may ask Mr. Brooks a quick question.
Go ahead.
Mr. Brooks, I know you talked about that there are some difficulties. I just want to make sure Are you still allowed to have access to your legal files?
So the legal files is something that I haven't been explained. I didn't know that there was conversations about the whole uh, flash file thing. I haven't even heard anything about that. I really don't know how. Somebody maybe here can explain to me how that will work. So I'm kind of like trying to figure it out myself, actually.
Attorney Covey, it's my understanding, based on what you've said, I mean, you believe the institution will accept the external hard drives, obviously any paper that you send through regular mail, just not banker boxes or large boxes full of materials.
Yes. So if I were to send them a 40-page packet of materials with appellate rules of procedure and extension notes and templates, I think any facility would allow that to be processed through, so long as I don't have clips or staples. As for, but they balked. My initial email, I don't have this memorized. I don't want to make a false statement, but my initial recollection when I first contacted that prison facility was to say that we were going to send them the files. I was told they would accept the file, but then when I stated, or when staff stated that it would be 5 bankers boxes, they put the brakes on that. And then there was some correspondence between their legal staff and my legal staff as to the best way to do this. We'll likely be buying some terabyte hard drives to put the materials on that to send to him. I don't know how much access you'll have to the library. I know in Wisconsin, you can go in almost every prison facility, unless you're in some kind of segregated status for a fight, for example, with another inmate, that you can make reservations to go to a computer library to review your legal documents. I also know that the time is quite heavily rationed. He's not going to have 8 hours at a time to look at these documents. So that will be a challenge for him.
I was just gonna say that too. There's no law library, which I've never seen a jail or prison without a law library. So I don't know how that's gonna work.
Do you have access to anything through a computer or online to access research material?
I have access to look at I believe it's Westlaw, and those are tablet based. But even that is challenging.
I use a tablet-based Lexis. It's a similar platform. It can be cumbersome unless you know how to switch to the natural language search engine and how to limit the jurisdictions and what you're looking at. But
So-
I think it's similar to what you had when you were in Waukesha, is that not?
No, Waukesha had Nexus Lexus, or however you say it, Lexus Nexus, or
Oh,
which is
they're very similar. If you figured out Lexus, you can figure out Westlaw. In my humble opinion.
Judge, if I may add one thing.
Go ahead.
Mr. Brooks, I know that without going into the substance, I recall about a 2-hour meeting when we went over a large amount of case law together. What I'm happy to do is I can send you those copies of those cases that we discussed.
I appreciate that. Thank you.
Thank you.
Thank you. Mr. Attorney Basie, is there anything the state wants me to consider or any additional information from the state today?
You got it.
All right, then, as I indicated earlier, and I'll just go through some of the law that pertains to this issue in making my decision. A person convicted in Wisconsin of committing a crime has a constitutionally guaranteed right to appeal his or her conviction to the appellate courts. That's directly from the Wisconsin Constitution, Article 1, Section 21, and case law State versus Perry, 136, Wisconsin 2nd, 92, a 1987 case. The right to an appeal includes the right that the appeal be a meaningful one. An indigent defendant is constitutionally entitled to the appointment of counsel at public expense for the purpose of prosecuting his or her one and only appeal as of right from a criminal conviction. And I'm citing to or from State versus Thornton, and that again is 2002 Wisconsin Appellate 294. And that court was citing to the US Supreme Court in Douglas versus California, 372 US 353 from 1963. There's no dispute here today that Mr. Brooks is indigent. This court has noted previously, I've dealt with this issue with Mr. Brooks previously prior to trial, but a criminal defendant may waive his or her right to counsel in criminal trial court proceedings, provided the record reflects that the waiver is knowingly, intelligently, and voluntarily made, and that the defendant is competent to proceed pro se. That's a citation to State versus Klessig. Appellate or post-conviction counsel appointed by the state public defender may move to withdraw from representation of a client, and in determining the motion, the court shall consider whether the defendant waives the right to counsel, and that's Wisconsin Statute Rule 809.30 sub 4 sub C. As I indicated earlier, at the writing of Thornton, no Wisconsin appellate opinions address the requirements for effecting a valid waiver of appellate counsel. Thornton relied heavily on Oman versus McCoutry, which was, although a Wisconsin case at that point in time, it was before the 7th Circuit Court of Appeals. The citation for that is 130 F 3rd 809 from 1997. I did review that case as well. And from that case, the Thornton court stated and found that before a court may conclude that a criminal defendant has knowingly and voluntarily waived his or her right to counsel on direct appeal, it must satisfy itself that the defendant is aware, one, of the florist's rights, which I've talked about, that's the right to an appeal, to the assistance of counsel for the appeal, and to opt for a no merit report that was briefly mentioned previously. 2, the dangers and disadvantages of proceeding pro se, which this court has, I think, exhaustively gone through with Mr. Brooks. And 3, of the possibility that if appointed counsel is permitted to withdraw, successor counsel may not be appointed to represent the defendant in the appeal. We know from the letter from the State Public Defender's Office, they will not appoint successor counsel, and that's a citation to document 690, filed February 26th of 2025. This court is satisfied that Mr. Brooks is freely, voluntarily, and intelligently waiving his right to appellate counsel. He confirmed many of the same requirements, if you will, that I went through with him at the time of his waiver back on September 28th of 2022. I just want to, I'm not going to read the entire excerpt into the record, but I am looking at the transcript, which is document 580 from that hearing, pages 75 through like 77. The court makes some findings that I believe are confirmed here today, and that's, he said today he had a GED that may have been referenced as an HSED. I think they're very similar. Nonetheless, Mr. Brooks has a high school equivalency diploma or a general education diploma. He's been able to communicate very clearly with not only counsel, but with the court. He's done that efficiently and effectively. He did not have questions for the court today. Frankly, this procedure went much more smoothly than the procedure and the questioning and answers back in September of 2022. And so I'm just going to rely and incorporate herein by reference many of the findings or all of the findings I made back then, because nothing has been presented to this court that would dissuade it otherwise, that he's intelligent, he understands the dangers and disadvantages of proceeding on his own. He's made the request. He now knows the SPD's position. He indicated it doesn't change his mind. We've discussed many of the disadvantages and potential pitfalls of proceeding on his own. He's in an out-of-state facility. He does not have the same access as he does in Wisconsin. We have some wonderful offers by Attorney Covey to send him additional information. He's aware he needs to file for an extension because the current deadline in the Court of Appeals is June 3 of 2025. So I have met, and through the colloquy here today, the requirements of the Thornton case, and I'm satisfied that he's doing so again freely, voluntarily, and intelligently, and with an understanding of really the dangers and disadvantages and of his rights to an appeal and to appellate counsel. And for all of those reasons, the court will grant Attorney Covey's motion to withdraw. And from here on forward, the court will consider Mr. Brooks a pro se litigant. We will be able to communicate directly with him. I would like an order. I don't recall if you sent a proposed order in, but if you would do that, Attorney Covey, I will certainly review that, sign it, and then we will send that on to Mr. Brooks.
I'll get that done before the end of the day.
Thank you. Mr. Brooks, anything else from you today? Attorney Covey?
Judge, I will make a request. Generally, once I'm allowed to withdraw, I'm cut off from the e-filing. I would request that I have the opportunity to send Mr. Brooks all of these materials, that I can file a letter with the court saying that we have done so, make a record of that, and then at that point, perhaps I can be cut off from the e-file if the court so desires. If there is some kind of issue where the prison won't accept anything, for example, then we would be able to address that. I just want to make sure that he gets his materials before I truly end my representation on this case.
You're asking that I delay the approval until you've been able to pull everything off from the court file that you currently have access through as an e-filer.
I guess you can sign the order at any time. I don't, and oftentimes I'm kept on the e-filing system even after I've been withdrawn. It's just kind of a quirk of the e-filing system. So we can sign the order at any single time, but I would, as a friend or as a courtesy to the court, I could still draft an update letter letting the court know that these materials got sent out. I'm not trying to complicate it.
That's okay. My clerk is advising me that we can delay removing you even though I signed the order of discharge.
Thank you, Judge.
Any objection from the state?
No, Your Honor.
All right. Anything else from the state today?
No, Your Honor.
All right. Thank you, everyone. That does conclude the hearing today. For purposes of our live stream, we just not turn it off for about 30 seconds or a minute because there's a delay in the broadcast. Then we want to make sure everyone gets there
Thank you.
till the end. Thank you,
Judge.
everyone. Good luck to you, Mr. Brooks.
Thank you.
Good luck, sir.
There's definitely something going on with the lower left side of his mouth. So Zach was probably one of the last times they're out of this, you guys. We won't see them again on this. It was just they had to be a part of it since they were part of the original trial.
Really have a great afternoon. Thank you so much.
It does look like Judge Darrell cut her hair, doesn't it? She took like it's short, or yeah, it's way shorter. She's so pretty. You're free, Mr. Covey. Bless your heart. I want to see something really quick. I want to go back here.
Not turn it off for about 30 seconds or a minute.
Look
because
at
there's
his
a
mouth.
delay in the.
I'm going to do slow speed because I'm weird that way. Turn that off. Look at the lower left side of his mouth. I feel like that's what he's covering up. And maybe that's why he grew a beard. I don't know. He's definitely trying to hide. See? His mouth looks jacked up. He's like, good to see you, Judge. Good to see you. You guys, oh, for everybody watching, if y'all aren't reading the chat while you're watching this, you really do have to go back and read my chat. These people in here are crazy. Y'all have some of the best one-liners, and y'all just crack me up. Thank you so much for the good laugh. I think we all needed it. He got Botoxed. He didn't get Botox. I don't know if it's just missing a tooth. It seemed like it was swollen. Just and when I say his left, like on his left side. So if we're looking at the camera, it would be the right side. Something's going on there with his mouth, though. It just looks jacked up. I said, I have no idea. Okay. Okay, here's my thoughts on this, and then we're gonna go watch Taylor Schabusiness. I don't think she had a choice. It didn't seem like there was any kind of bad blood between him and his attorney, but he insisted that this is what he wanted to do, so she lets him do it. And she did it like she did the first time. She went through everything. She got his okay. I understand. Yes, ma'am. I do this. I do that. And of course, he still has his same, and he'll come back and say that she didn't do this or she didn't do that, but it's not going to matter. Just like it didn't matter in trial, because she's done everything legally that she has to do. And she probably goes a lot farther than most judges would, but I don't think that hurt her. And I don't think that hurts the case at all. Honestly, it actually probably is going to help with them denying the appeal, in my opinion. Just my opinion. Okay. So I heard things today got really crazy over at the Taylor Schabusiness hearing, that she flipped out in the courtroom or something. Wait, it's like today's like a deja vu of deja vu. First of all, I can't even. It's just, what's up with Taylor Schabusiness has done this before. We've seen it before. And we're looking at Brooks again today. I mean, it's just crazy. Let me go back to my regular setup. Oops, sorry. Oops. Okay. So I don't want to listen to court TV do a bunch of talking. I want to get straight to the hearing. So let's go. Are you guys familiar with Taylor Schabusiness? If you're not familiar with her, this was the crazy woman who, and I do think she has some there's no doubt this woman has mental issues. For the longest time, I thought she was doing all this so that they would put her in a mental facility because she thought maybe it'd be easier. But I really think this girl's messed up. And she attacked her first attorney at one point in the courtroom. That all happened early on in her, like I think even before her trial started. And then now she's back in court because, the first time she was in jail was because she unalived her boyfriend. And after unaliving him, she wasn't done with him. I'll just put it that way. His mom found, I can't even say it on YouTube. His mom found him in the basement, part of him in the basement. So she was convicted of that. And then now I guess she attacked someone in jail. She attacked a guard in jail. So now she's having to have a hearing on that. And this was a motions hearing, I guess they were having, or pre-trial hearing. So let's get to it.
All right, the court will call 24 CF 1048 State of Wisconsin versus Taylor Schabusiness. Appearances.
Gordon Leach for the state.
Taylor Schabusiness is personally present. She is in custody with Attorney Curtis Jelka.
All right, this matter is set for a preliminary hearing today. Mr. Jelka, what's the status?
Your Honor, my understanding is we are proceeding.
All right, Mr. Leach.
Your Honor, I'm just checking in on the status of my officer. I expected her to be here, but I'm also having connectivity problems here. I might need to run upstairs and see if she may be upstairs. If I can have them.
Sure.
And Judge, it sounds like just one witness. We're asking for sequestration, but that may be a moot point.
All right.
It is one witness, Your Honor.
We're off the record.
Okay, boy, that didn't take long, and they.
For sequestration, but that may be a moot point.
All right.
It is one witness, Your Honor.
All right. We're off the record.
Okay.
You notice she looks at the camera first and then she attacks him. She's just sitting there and everything like that. She looked at him a couple of times, but after the camera goes back to the defense attorney as he's saying something, she clearly looks at the camera first, then attacks him. This is all a show. And next, she has put herself in a position where the court would be well within their right and authority to remove her from the courtroom, that she would be seeing
Sequestration, but that may be a moot point.
All right.
It is one witness, Your Honor.
All right. The court will call 24 CF 1048 State of Wisconsin versus Taylor Schabusiness appearances.
Gordon Leach for the state.
Taylor Schabusiness
Oh,
is
it's muted.
personally present. She is in custody with Attorney Curtis Jelka.
All right. This matter is set for a preliminary hearing today. Mr. Jelka, what's the status?
Your Honor, my understanding is we are proceeding.
All right. Mr. Leach.
Your Honor, I'm just checking in on the status of my officer. I expected her to be here, so, but I'm also having connectivity problems here. I might need to run upstairs and see if she may be upstairs. If I can have her.
Sure.
And Judge, it sounds like just one witness. We're asking for sequestration, but that may be a moot point.
All right.
It is one witness, Your Honor.
Okay, so they're talking about the witness, which is probably the person that she attacked. So could it have been a female prison officer?
We're off the record.
Attorney's like, well, what can you do? It's another day at the office. What type of people is he used to representing? Good gracious, let's see. So obviously they're going to end up taking her out. Did they even show the rest of it? No, they never came back. They never even came back and showed the rest of it. let's see, this was yesterday. This was You guys remember when her therapist was talking about her, about how she tried to have, she doesn't communicate with you. She doesn't look at you in the eyes. And she had a really hard time just trying to interview her or talk to her at all. I think she hears things. I really do. I know a lot of people think it's fake. I truly believe that she does. Which is the way she acts. It's just some of that stuff she does, you can't fake it. It's like, why is she shaking her head? Why does she smile and do her eyes? It's almost like she's having an internal conversation with herself or something. So, psychosis from prolonged drug use. I think it'd have to be. I agree that I feel like there's probably something there from the drugs, but it's got to be. There's got to be more to it. There's got to be an underlying issue, I think, to begin with. I don't know. Like I said, I used to think she was faking it, but it's just. I don't think she is anymore. I think she's definitely troubled. A lot of you guys think she's a fake. Yes, yeah, exactly, Denny. She did that whole thing through the trial. David said a secure mental hospital is worse than a prison. Oh, she did come back in a hood. Okay, well, I want to see that part. So let me just. Do we really need to watch this again? He doesn't really even speak. Because, see, I don't think she. Like, even when they're trying to talk to her, she's not giving them any kind of answer to help her case, to help them help her. It's so odd. See, of course, it can't. Everything that's popping up is her attacking her attorney. Nothing about the actual hearing itself. 9 minutes long. Is this it right here? Okay, maybe this is it.
Ms. Schabusiness is now down in the jail. She's appearing by Zoom from the jail. The last time we were in court, there was a commotion. She had yelled, stood up. She was then physically detained, moved out of the court, and moved down to the jail. It appeared, I didn't see exactly what happened with it. It appeared that she had tried to get at an attorney. And so the court does now find that Ms. Schabusiness is waived her right to be present during the outburst. Are we prepared to proceed with the preliminary hearing?
Yes, you are.
Your Honor, I'm requesting to withdraw at this point in time.
Your request is denied. For this hearing, State versus Case 175 was second one. You can continue for this hearing, and then you can withdraw for that.
Okay.
Thank you, Your Honor. The state does call Detective Milan.
Do you solemnly swear that the testimony you shall give in this matter before the court is truth, the whole truth, and nothing but the truth, so help you God?
I bet that's her. I bet that's the prison guard, and I bet that she's the one that was attacked. What do you guys think? That's what I'm thinking, right?
Ms. Milan, if you want to state your name and spell your last name, I'm sorry, Detective Milan. If you want to state your name and spell your last name for the record.
Christina Milan. Christina is with a K. Milan is Meilahn.
Mr. Leach.
Detective Milan, where do you work?
I'm a detective at the City of Fond du Lac Police Department.
As part of your duties as a detective,
Never mind.
on occasion, you review the reports of other officers,
I do.
and as well as, do you also review sworn complaints that are filed in the courts?
I do.
And are those complaints what do they typically rely upon?
They rely upon the reports of the officers that respond to different complaints or incidents within the city of Fond du Lac. They also rely upon witness statements, videos, any other evidence that is brought to the attention of the officers or investigators as they're putting together their case.
Do you know an officer, Lindsay Lukey?
I do.
And have you reviewed reports of Officer Lukey in the past?
I have.
And do you find that Officer Lukey is accurate and truthful in the reports that she makes?
I do.
Now, do you know whether Officer Lukey investigated an incident at the Tachita Correctional Institution that occurred on July 24th, 2024?
I do.
And how do you know that?
I reviewed the criminal complaint for that matter.
And was that a sworn complaint by your agency?
Yes.
Whose report did that rely upon?
Officer Lukey's.
Thank you. Can you tell us what, who's involved in the incident on July 24th, 2020?
Objection, Your Honor. Well, I know hearsay is admissible at preliminary hearings. I don't believe that there are any personal observations from Detective Mylon involved, so she's in essence a conduit for hearsay and doesn't have any information of her own to benefit the court.
Your Honor, as Attorney Joko pointed out, the court can rely upon hearsay. Detective Mylon has testified that she has reviewed the sworn complaint in this matter that does rely upon Officer Lukey. Detective Mylon further has testified that Officer Lukey is reliable or trustworthy in the reports of the investigations that she reports upon. I believe that would give it sufficient reliability for purposes of preliminary hearing today.
Can you repeat the question, please?
Yes, thank you. Do you know who was identified as being involved in the incident that Officer Lukey reported on that occurred on July 24, 2024 at the Tachita Correctional Institution?
Yes, it was an inmate at Tachita Correctional Institute, which is located in the city of Fond du Lac, county of Fond du Lac, state of Wisconsin, by the name of Taylor Schabusiness.
All right, and are you familiar with Taylor Schabusiness at all?
Not from personal interactions. I have reviewed her photo spread through the Department of Corrections for inmates, which provides her physical appearance.
All right, do you find that reliable?
I do. I use it often.
And can you, did you see Ms. Schabusiness here in court at all today?
I did.
All right, when was that?
Earlier around 8:30 this morning.
All right, and do you see her or her represented in the courtroom today?
I did see her represented in the courtroom today.
All right, and do you see her now? And
Yes, she's on the video screen to my right.
And what is she generally wearing? You just described.
Orange jumpsuit.
Your Honor, I'd ask the record to reflect Detective Mylon has identified the defendant in this matter.
Your Honor, no objection, subject to cross.
The record will sort of.
Detective Mylon, what did Officer Lukey report occurred at Tachita on July 24th of 2024 involving Ms. Schabusiness?
Taylor had indicated that there was a staple in her arm and a request was put in for a nurse to. One of the correctional officers at Tachita, a female sergeant, was tasked with bringing Taylor down to the nurse's office so the nurse could remove that staple. While in the nurse's office, Taylor began giggling, and then a short time later, when the nurse was in the process of removing the staple with the tweezers, Taylor lunged initially at the nurse, then the sergeant pushed the nurse out of the way and began to try to gain control of Taylor, to get the nurse out of the way. And in the process of that, metal tray from the nurse's room was grabbed by Taylor. The correctional officer believes she was struck in the head by that, does not believe she was concussed, but then reported in the course of struggling to get Taylor under control, received bruising to her ribs and pain in her arm.
And did the, was it a sergeant, I believe you said?
A female sergeant, yes.
Thank you. Did the female sergeant, did she report having any pain from being hit in the head?
She reported having pain from the entire incident and did seek medical treatment for potential injuries.
And did the sergeant say whether she had consented to Schabusiness injuring her in that fashion?
She indicated she did not consent to that occurring.
No further questions, Your Honor. Mr. Gelman.
Thank you. Detective, did you review the video in this case?
I did not.
So you're solely basing your testimony on the criminal complaint today, is that correct?
That is correct.
So, just to review, the moment prior to the alleged lunge, there were 3 people in the room? Is that your understanding?
From the criminal complaint, that is my understanding.
And are you familiar with Tachita, whether they have any process for identifying or making sure they have the right patient in the room at any given moment?
I'm not overly familiar with their procedures, but I have responded there for numerous incidents, and most inmates do have a number or a system for identifying them.
You don't know if Ms. Schabusiness was wearing any such identifier that day, correct?
I don't know that.
Okay. So the moment prior to what you described as a lunge, where were the parties positioned, if you know?
I can't say other than the nurse was in the process of taking the staple out at the time, so within close enough proximity to do that.
Okay. And just to take it a moment further, Ms. Schabusiness allegedly lunged at the nurse?
Lunged or caused some motion in which the sergeant was concerned for the nurse's safety.
Okay. And then did the sergeant effectively intercept her, or did she actually make contact with the nurse, if you know?
I know the nurse was asked if she was hurt. I'm not sure if it was direct contact, incidental contact, but there was questions of whether the nurse was injured.
Now, the person described as the victim in the complaint, that would have been the guard, is that correct?
The female sergeant, yes.
Okay. And she indicated the number of injuries, including pain in her head, but short of a concussion, bruised ribs, and a hurt arm, is that correct?
Correct.
Did she attribute how her ribs had been bruised or her arm had been hurt?
It was not stated in the criminal complaint if she mentioned that.
Okay. But the head injury, I guess, would be related to a tray hitting her?
It was inferred that, yes.
Okay. You don't know anything about the specifics of that tray, correct?
I don't know any specifics other than the nursing trays that are used by nurses.
Okay. Was there any exclamation or sound that Ms. Schabusiness made before she allegedly lunged?
The only thing that was discussed was like some giggling or some laughing that preceded that. The exact timing of that proceeding was not outlined in the criminal complaint.
Okay. So you identified Ms. Schabusiness as the defendant earlier today, correct?
Yes,
You have no way of identifying her other than the complaint as the person present in the room at the prison, though, correct? You didn't see any video, you weren't there?
I wasn't there. I didn't see that. The sergeant identified her and the nurse identified her from previous contacts.
Okay. Thank you, that's all I have.
Any reader?
No, you're.
Are you gonna set that? Mr. Leach, any other witnesses or evidence?
No, you're.
Mr. Jelka, any witnesses or evidence?
No,
Mr. Leach?
Your Honor, without argument, the state asked for finding.
the judge would just briefly argue the identification. Detective Mylan identified Ms. Schabusiness based on booking photos. Doesn't have any personal knowledge of who was present in the room at Rashida, didn't even see the video, so I would move to dismiss, the argument being the identification was inadequate at this time.
The court will find probable cause that the felony was committed, was likely committed by Ms. Schabusiness. The case will be followed to.
Judge Nails.
Mr. Leach, do you have any information?
I do, Your Honor. I'm providing a copy to Attorney Joka and to the court.
Mr. Jelka, subject to local 10-year rule for substitution, do you want to proceed for, with an arraignment?
Your Honor, that was my understanding for today. I would defer to Ms. Schabusiness if she still wishes to continue with that today.
Ms. Schabusiness, do you want to proceed to an arraignment today?
Yeah,
Yes?
yeah.
Okay. Go ahead.
Your Honor, I have received the information. The charges appear to be identical to the criminal complaint. Would waive its formal reading and subject to 10 days to decide whether to substitute would enter not guilty pleas.
Not guilty, please enter this matter. We schedule moving forward. Anything else from the state?
No, Your Honor.
Mr. Jelka, anything else?
No, thank you.
Please adjourn. Thank you.
Well, that was fairly quick. All right. So what have we learned? They're not going to, what did he say? What did the judge just say last? Because I missed it. Oh, you guys are still talking about Darrell. So we didn't get a decision. That's what I thought. I was like, he didn't say what happened, did he? I didn't think he made a decision. Yeah. Okay. Wow. Wowzer. Did you guys also hear about there's some more video that's put out and pictures of the house over at the case that we've been talking about in Connecticut? The held captive in Connecticut case? I haven't put it together for us to watch yet, so I got to do that. So I'll probably get that off for you guys either tomorrow or the following day. But yeah, if you're here to watch the Darrell stuff, you have to rewind because we did that at the very first portion of this video. And then we went and watched what happened with Schabusiness today. All right. Well, big day in court, people. Big day. Big day. It's a way to start the weekend off, right? Okay, as far as Darrell, we're not going to see him again, you guys. This is probably it. That's probably the last time we will see him. Wouldn't you think? Because he's the caged bird. They're not going to show anything with the appellate thing. I mean, we're not going to get to see. We don't get to see that kind of stuff. So, yeah, and let me just say, I had said earlier that I would say I was wrong if I was wrong about where he was because I had said that he was at Florence ADX. My understanding is he might have been there for some time, but then was transferred away. I don't know. I don't know if that makes any sense or not. But according to all of this information that we've obtained today, he's in South Dakota or North Dakota. And I did look up the prison there. Let me show you guys really quick. Max security. I just had it pulled up. That's what I was looking at. So they specialize in his specific style case or whatever. Let's see. Share this with y'all. It's located in Bismarck, which housed adult male inmates and is a part of the North Dakota Department of Corrections. I saw something about, okay, it offers various programs, including substance treatment, conflict resolution, and alternatives to violence. The segregation unit is now called the Behavior Intervention Unit and has been redesigned to focus on behavioral treatment and skills development. Okay, this is the one I was looking at. The James River Correctional, I think. No, that can't be it. Oh, damn. What do I want it? I missed it. I thought I saw. Oh, for freak's sake. Let me go to my history. Supermax. Oh, what did I say? Is it South Dakota or North Dakota? What did they say, y'all? Let me look in the chat because I know y'all are, it's not North Dakota. I knew y'all would be yelling at me in the chat. Go ahead with your bad selves. Hang on. That's why I couldn't find it. So hang on. Leave it to you guys to keep me in line. Okay, G. Norton, Jameson, NX. The security facility is the highest security prison in South Dakota, housing maximum custody inmates, and serving as a disciplinary segregation unit. So, see, that would make sense, right? South Dakota State Penitentiary in Sioux. Is it called Sioux Falls? I don't know. Sioux Falls. I don't know how to pronounce that properly. I'm from Alabama. The highest level security houses maximum custody inmates, has a mental health unit. Ooh, they also have a minimum center for minimum security offenders located outside the perimeter fence. But we know that Darrell isn't going to fit in that. So hang on. Has housed notable inmates, including those convicted of red rum and other serious crimes. But it has struggled with a host of recent security incidents since March of 2024, including unrest at the penitentiary and fighting at the other state prison. Okay. Oh, well, let's go. Let's look at the pictures. And so I was trying to figure out, like, because he was wearing a tan suit. Yep. See, he's got on a tan suit. That's where he's at, y'all. And Laura and I were over there trying to look it up while we were all listening to his trial, because I wanted to see if that made sense that he was in a tan suit and being at Florence ADX, as is what we were told, what my informant had told me. So I don't really see, there's not a whole lot of pictures. I was hoping there'd be more, but there's not. That's where they eat. Or no, you know what that was? That was the visitation center, I bet. Well, interesting. Okay. Denny says, I just rewatched when Schabusiness attacked the other lawyer 2 years ago. I know. It's like she needs to come up with a new thing right now. Yeah. You think he has a fan club. Oh, I bet he has a fan club in prison. I bet he does. They probably call him whatever they want to call him. All right. Well, thank you all for being here with me today. I'm sorry that I didn't have a lot of notice on this one. I didn't think it was going to happen, and so I did put the notice up late. But we made it in time. We got to see the whole thing together. So I appreciate you all. Thank you so much. Don't forget to like and subscribe if you haven't already. We're going to be following Lori Vallow Daybell's trial. We've also been watching Courtney Clinty's trial. What's that other chick in Utah? What's going on with Utah, you guys? I just saw another case the other day in Utah. Something else is going on over there. We've got Jennifer Gledhill in Utah. We've got Corey Richens in Utah. Just all kinds of stuff going on. And we're following this captive in Connecticut case too. So please come back again and join us on another day and watch us with other cases as well. Y'all be good.